I've called the case, counsel.
Never don't trip out for the defendant. You know, versus not what's done. It's P7, like, Connor.
All right. I'm almost afraid to ask where we are on this, but I have three motions, I think, before the court.
Yes, in terms of my motion, I put forth a motion to withdraw as counsel to break down the communications.
But you filed motions in limine also?
Yes,
And motions to compel discovery.
yes.
Okay, well, I'll hear those and then I'll hear your motion to withdraw.
Okay, and in regards to the motion, the motion to compel the discovery.
Well, it's a motion to compel specifically depositions.
Yes, we put forth a motion to compel deposition as during our second court day, we respectfully requested the court consider depositions in regards to three people that we think are important in terms of the facts of this case. The things of the interest of justice. There's a numerous amount of allegations against my client. We think that these people have information that would be helpful in presenting a defense. There's a number of witnesses, a lot of allegations against my clients.
Why would I need a deposition of a police officer?
The police officer was involved in regards to the investigation of several complaints that have been alleged against my client.
So why would he need to be deposed, I guess?
That's what my client is requesting.
Okay. So there's not a basis other than a request and a wish or desire.
He wishes to speak himself if he can be heard.
Go ahead.
Morning, Your Honor. Thank you. The reason I've requested the position of Officer Lawrence is because, as we've alleged, this landlord has the management. The real reason for this lawsuit against us is retaliation, because I reported them to Michigan, and that they have weaponized Solani Police Department.
These people weaponize Ipsy PD? Okay, you can stop there because that request is denied. Without more, that is absolutely denied. If you're going to tell me some landlord decided to weaponize the police department,
Well, not that
that's going to be a complaint you're going to have to address as the police department. And I don't believe it. Why would the keeper of the records for the plaintiff need to be deposed?
Because that goes into the heart of the matter as well. When they started a plan, a motion to try to look at me, making me look bad, which then essentially led to this lawsuit for eviction. They committed certain acts in the office and on the body cam too that I've actually reported all to, I should state, to strengthen my argument here.
What?
We find.
Is there a specific person you're saying did all those things? Because I don't know who you're referring to as the keeper of the records.
I don't understand, keeper of the record, what does that mean?
Right.
Looking at your motion to compel deposition. Paragraph 8D. Plaintiff's keeper of the record.
Your Honor, I think what he's referring to in regards to that is he believes that there's information that will help exonerate him from the charges, such as video or cameras set up around the complex. And
Have those been requested?
discovery's been questioned, yes.
And that was camera footage and the like?
All discovery was requested. Even electronic discovery. So the full range of discoveries was requested.
And has plaintiff not provided it? I guess I'm not clear if it's been requested. Where does a deposition help with that?
And I mean,
Go ahead. I don't care either one of you because
Oh, okay, yeah.
I mean anybody can dig a hole for themselves. So go ahead. You two bet it.
Well, there are certain acts behind the scene which I think they've committed to the management to essentially weaponize a few other tenants too. Your Honor, we've filed a complaint with Michigan Department of Civil Rights, and we even met with the state administrator a few weeks ago, Cindy and I, and they opened up an official investigation on April 29th against the landlord for 4 items: retaliation, disability, and discrimination on the basis of national origin and sex. And that investigation is active. Plaintiff.
Okay.
Attorney.
Assume everything you say is correct.
Yes, sir.
Why do I need a deposition?
Deposition is to essentially dig for more information.
That's not the way that works.
That they've done. That's my.
Who is Paul Spencer?
Paul Spencer is the CEO of K&G Prestige.
You can stop there. You can stop there. Why do you need his deposition?
Because Paul Spencer is the one who responded to an email that I'd sent to our Michelle board and him. My email was dated March 2nd. And within a few days, he decided to, and he emailed them saying essentially he's going to evict us. And they're retaliating and against Sydney both. So it's important that Mr. Spencer is deposed.
Why?
I thought it would be getting some more information. My mind that we could expose more information for the clarity of the court.
So it's a fishing expedition.
Fishing expedition. Well, to try to find out what happened behind the scene. Sure, under oath to be deposed.
Who is Sheena McMicken?
She is the on-site manager who will be here at the jury trial to testify.
So why do you need her deposition?
She's the one who also made all these false and allegations against me, which are listed in the with summons, many of which actually don't apply to me. I found that on Saturday, just this past Saturday, because there were complaints by tenants who don't even live in our building, and it wasn't even about me. And they used those as a basis to file this complaint with this court. which in my view is, well, it doesn't matter what my view is. So there's so much behind the scene that they've done. One of these complaints, actually, which I think may be valid, is a complaint by tenants who was essentially poached and helped and weaponized.
Everybody's being weaponized.
Well, not everybody, not everybody, but a few, yes, who got all the facts. She made allegations that are untrue, baseless, and so admitted responsibility in a complex for a poor maintenance job that they've done. They blamed me.
Have interrogatories, and I think there were interrogatories, requests for production, and admissions.
Yes, Your Honor. We served the plaintiff that we received approximately 360 pages in terms of discovery. I served another request for admissions interrogatories just last week. So, I mean, in terms of what.
And all of those have been answered.
All right, if I may, we responded to the first set, gave it to him on Thursday afternoon. Friday, he drove another set to my office from, so we got that to work on still, Your Honor.
How many interrogatories are there?
This is the second one that I drove is all.
Well, listen to my question. How many interrogatories are there?
He did not constitute it over when Your Honor. We're just going to respond to him because we're not going to try and play those games. But,
No, I understand, but I also, in district court, you have to ask permission before you get any of that. I'm not saying that you didn't get the court permission, that there could be limited discovery, but I also don't, I guess, allow discovery or use your client's phrase to be used as a weapon or weaponize it to try to bury somebody to do something. I mean, it seems to me that they've responded to the discovery request. I'm a bit concerned that then there becomes a second set of discovery. When this really is a landlord-tenant case. All right.
I would have to double check, but I think in terms of the number of interrogatories, I think it's under 30 questions. And then request for admissions, I think is probably like another.
So under 30 questions.
I think it's like 15 to 20 questions. I mean, sorry, 20 to 30 questions in terms of interrogatories, and about maybe about 18 or 20 request for admission questions.
Yes.
I would object to dropping the deposition.
You what?
I don't object to the dropping the our request.
So now you don't want depositions?
Guys, I'm thinking a little bit more.
Well, that's probably good because your motion was going to be denied.
Yeah.
So, I don't need a response on that motion, Mr. Gannon.
yes, sir.
The motion to compel this depositions is denied. I would also indicate that at this point, plaintiff can answer the other set should they so choose, as well as a request for admissions or the other set of interrogatories. But I'm not going to allow any further. I think the process is being abused. And so I'm not going to have any further discovery without the permission, express permission, and written permission of the court.
This may be one of the biggest rulings of the hearing. The judge has essentially put the brakes on the discovery process because he believes it's starting to spiral out of control. That's a strong management decision designed to keep the case focused and prevent either side from overwhelming the other with endless requests. If you were the judge here, would you have limited discovery too, or would you have allowed one more round? I'm curious where you stand.
That, but any additional request, there needs to be written permission from the court to do so.
Yes, sir.
Motion in limine.
Your Honor, the motion limited was filed, I think that is, we're gonna withdraw that motion limiting, see what plans provide in terms of discovery. And if appropriate, if I remain the attorney, maybe file another, motion limiting.
I don't understand why I have this now, if that was. In response to the motion in limine, Mr. Gann.
I did submit a response to it. I think the timeliness is the real issue here. How would you know what evidence you want to exclude without even knowing what evidence has been produced yet? In addition, there is a federal statute 24-247.6, which does allow landlords additional grounds for termination that were not known to the landlord at the time of the issue. And until discovery is complete, I think this is premature motion.
Well, this motion in limine, I understand they want to withdraw it, but I think we need to make this record clear. I'm going to deny the motion in limine. I think there were only three, right?
Let me draft an order for those two, Your Honor.
No, I have people that will do that.
Thank you.
Yeah. And the motion to withdraw.
Yes. Respectfully requesting to withdraw. There's been a breakdown in communications in regards to this matter. That breakdown has remained for some time. I'm respectfully requesting to withdraw.
Nori, or do you have a response to that?
Yes, if I may, sure. I've asked Attorney Ogletree what specific examples, events, behaviors, words, anything. My part. It was right him to make that decision. Asked him a few times, the emails. He hasn't provided any specific examples. I usually try to have most of my communications via email. It's a matter of record. So it wouldn't be hearsay. My word against your word and something. So, Ogletree told me that it was it's going to be teamwork. I said, great, collaboration. So, and I'd like to be as part of that. I'd like to be in the loop, and I should be with the clients here. It's something very important, and a few conversations took place, and a few things we hashed out. I'm assertive, but very respectful. And I don't know which one of those things that we discussed between us set him off. I have no idea because he hasn't responded. So about 3 weeks into the session, or essentially the process, which was about 3 weeks ago, roughly, then he decided to withdraw. He said that I wanted to litigate the case, and I was disrespectful and demeaning to him. and he still hasn't provided an example to me. I've never disrespected him. I don't like him, and and we have this professional
Well,
relationship.
you guys probably need to figure it out, and I probably don't need to. Normally, I wouldn't stand in an attorney's way to get out of a case, but you're objecting. Usually, that's not the case either. So I'm going to, at this point, go ahead, counsel.
I'm limited in terms of
What you
saying.
can say. I know.
Yes. I mean, but I have put in writing in regards to this. I'm just trying to think of what I can actually say. There's not attorney-client privilege.
I get it.
My hands are kind of tied of what I can say. I would just say I think that at this point I may have a conflict versus my, and that's the only other thing I can say.
How
Now the case takes another interesting turn. It's no longer just about discovery. It's about the attorney-client relationship itself. When a lawyer tells the court there's a potential conflict, but can't fully explain it because of attorney-client privilege, the judge has to balance two competing interests, protecting confidential communications while making sure the case can still move forward fairly. These situations are never easy, and they can completely
Well,
change
I
the
have
direction of
a
a lawsuit.
final settlement conference on the 7th, already set in this case. So on August 7th.
August,
What?
August 4th is the first.
Then you have.
Is it the 4th or 7th?
Oh, except for the 4th and then the 7th.
4th and then the 7th. Right. Okay, got you. Um, I think what I'm going to do on the motion to withdraw, and Mr. Zedidori, I just want to make sure I'm clear on it. You're objecting to counsel's motion to withdraw?
We need to have an attorney.
Pardon?
Have an attorney.
Okay, but you don't need to have this one if there's a problem.
I haven't had a problem. As I said, I communicated and continue to communicate with them.
Well, maybe you guys can figure that out. What I'm going to do is, when is the discovery due?
We just received another one on Friday, so that would be, you didn't put a close of discovery.
That was the second one.
That was the second. The first one we've responded to already. I believe we gave theirs to them a couple weeks ago, so probably 14 more days, I would assume, would be when that one's due.
You'd agree with that, counsel? About 14.
Yeah, roughly about 14 days. But I think what he's saying is he's asking for if there's some type of legal aid program that can appoint an attorney.
Well, you just saw him in here. You can go to legal aid. I mean, we'll give you a number to call them, but
We have already contacted them before, I mean, a while ago,
and
not recently, yeah. Well, yeah, even a couple of weeks ago when I was wondering what's gonna happen, they said that they're not, they don't have the resources for an attorney who's gonna be fighting.
all right,
We're wondering if the court could assign a pro bono attorney
I cannot assign an attorney on a civil case.
to a civil case. Oh. Yeah.
I would just respectfully, again, just request to withdraw. Again, I believe I have a conflict in this matter.
What I will do is I will grant the motion to withdraw any notices, discovery, or anything like that are to be sent directly to the defendants in this case at the 939 West Clark Road, number 101, until further notice of the court.
We rescind the first set of interrogatories. Has that already been given to
Well, he's under an obligation to make sure that that they have them. I don't think.
So,
Okay.
so that was shoot out for you.
All right.
And Your Honor, just for clarification, I know you've got it set for a jury selection. Is it August, September? At the end of August, I'm gonna be out of country, so I just want to make sure we don't.
I have it set for jury selection August 10th.
August 10th.
Right, August 10th for selection.
How run your selections, Your Honor?
Pardon?
How do you run your jury trials? Is
Very well, thank you.
I
But
understood. As far as the timing, is it the next month, the next week, the next day?
it can be the next month.
Okay,
We'll work with timing in terms of, I work with counsel. If we select, I work with counsel in terms of timing of the jury selection. Also understanding this being a civil case, the
criminal.
criminal cases take precedent.
Understood.
I would also indicate has how much is monthly rent?
155, Your Honor.
Okay.
It's a, by the 7-day last week, an escrow order, as well as an order to have no negative contacts with all named.
Yes. So, well, I just wanted to make sure that escrow has been complied with, so it has been thus far. All right. Thank you.
Yes, question.
Yes.
Pay the May rent into this. I know you said starting as of June, but could we pay that to the courts too? But they didn't take the rent. Maybe
We'll-
it's from us.
We'll never object to them paying more rent to the court. As Part 4 is required us not to take May.
Right. So you can pay the maid to the court. That's fine.
I can.
Yep.
Oh, okay.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you.
Thank you, Your Honor.
That's all yours.
Yes,
And that's where this hearing wraps up. But the bigger legal battle is far from over. The defendant lost the request for depositions, discovery has been tightly restricted, and the attorney has officially been allowed to withdraw from the case. That means the road ahead just became much more challenging. Do you think the judge handled this hearing fairly, or should the defendant have been given more opportunity to gather evidence? Share your thoughts below, and if you enjoy detailed courtroom breakdowns like this, don't forget to like, subscribe, and I'll see you in the next case.